Good day. My name is Frederik Plessis, and I'm a legal advisor within SEESA Consumer Protection and POPI Department in Pretoria.
Good day. My name is Melinda van Merwe, and I'm also a legal advisor in the Consumer and POPI Department.
Melinda, today we are going to discuss the Protection of Personal Information Act, also known as the POPI Act, which is a new all-inclusive piece of legislation that protects and safeguards the integrity and sensitivity of personal information. Of our core discussion today is going to be one of the conditions, which is the processing limitation, which in essence deals with when you collect personal information, it should be adequate, relevant, and not excessive in nature.
Yes, Frederik, and that's why today we'll be having a discussion around how our clients and companies can process personal information in a lawful manner. Frederik, before we start to talk about lawful processing, can you maybe just explain to us what does processing of information means in terms of the POPI Act?
Melinda, that's a good question. So basically, we refer our clients to go to Section 1 of the Act, read through that specifically, and which specifically gives the definitions of processing and further definitions set out in the Act. However, for our discussion, in short, it basically entails the following. It's receipt, recording, or collection of personal information.
Frederik, if you read Section 10 of the POPI Act, you would see personal information can be processed if the purpose for processing that information is given to the data subject, if it is adequate, relevant, and not in an excessive manner. Now, Frederik, can you maybe tell us, in terms of Section 11 of the POPI Act, when can a company process personal information?
Yes, Melinda. So Section 11 specifically states that when you collect personal information, you can collect it directly from the data subject, basically the person whose information you are collecting, or a competent person on behalf of the data subject, where it's absolutely necessary to collect that information, where it's a legitimate interest of the data subject, or any other third party, where it is required by law, or where it's a public law duty.
So, Frederik, what you're saying is that if information is processed, it must be compatible with the purpose of collecting that information from a data subject. Responsible parties should always be aware of these numerous aspects, including the manner how the information was collected, the nature of the information, and the purpose for why that information is collected before they process that specific personal information from a data subject. It is clear that companies should establish what information is really required from the data subject before they collect it and before they process that personal information. Frederik, can a data subject object to a company collecting the information and processing the information?
Melinda, at any given time, any data subject may object to the information, as long as it is in a reasonable grounds, in a specified manner, unless required by law, or in direct marketing, unless it is unsolicited electronic communication. Furthermore, once an objection has been received, the responsible party should stop processing that information. Hence the reason why we request of all our clients to basically collect the information directly from the data subject. However, Melinda, we are aware that there is specific exceptions to that. Can you maybe share that with us?
Yes, Frederik. So we tell our clients and advise our clients to get information directly from the data subject, but there is exceptions to this rule. So the first one, if this personal information is public record, you don't need consent, or if the data subject consented to you getting that information through another third party or in another manner, then you don't need that specific consent. And thirdly, if it is necessary to get information from a third party, let's say for national security, for criminal investigations, or if to get information for a court proceedings, then you can get information from another third party without consent from the data subject.
So Melinda, in essence, what you are saying is that when you collect the personal information or process the personal information, it should not risk the privacy of the data subject. It should only be collected when there is a legitimate interest or where it's absolutely necessary, where you can get consent from the data subject directly to get that and keep that on record. Once the data subject has objected to the information being collected or withdrawn the consent, that you as responsible party should stop using that personal information.
Yes, exactly, Frederik. So organizations and companies must be careful when they process personal information from a data subject. Processing must be lawful at all times, and personal information may only be processed if it's adequate, relevant, and not in an excessive manner.
Exactly, Melinda. So basically, all of our clients and the listeners hereof should collect only personal information when it's absolutely necessary, therefore, and it's for that specific purpose. If you require more information regarding the Protection of Personal Information Act or the condition processing limitation, please contact your nearest SEESA office or SMS the word SEESA to 45776 for professional legal advice, or visit our website on the link below. Thank you very much, Melinda.
Thank you, Frederik.